I'm good.
You're on.
Feel like. Testing.
Headphones.
Okay. Excuse me. Welcome everyone to the July 10th, 2026 Minnesota Clemency Review Commission July meeting. And we apologize for a slight delay and want to start with our call to order. Roll call of officials. I guess I'll start. I am Vice Chair Glenn Burt.
Commissioner Catherine Messrick. Commissioner, excuse me, Carly Bad Hartful. Commissioner Artika Roller. Commissioner Perry Moriarty.
And Commissioner Carl Crawford.
And Carly Stark, Executive Director of the Clemency Review Commission.
Next, we will move to approval of the agenda.
So moved, Crawford.
Second, Messrick.
Thank you. And now we will, excuse me, sorry. Director Stark, will you please?
We don't need a roll because nobody's online. If it's an aye or a nay.
For the approval of the agenda, all in favor say aye.
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 Anyone disagree, say nay. There is none, so agenda is so approved. Thank you.
Yeah, so I will be sort of facilitating the next part of the meeting since this is a new process for us. As we've talked about in previous meetings and the commissioners know, and the public knows because it's on the agenda, we're going to talk about the commission's discretion to deny commutations without a hearing. We have put every case that meets one of the three criteria for denying without a hearing on the agenda without a recommendation. It's just these meet these criteria. The board or the commission can make a recommendation, but they don't have to. If no recommendation is made, they stay in the queue and are subject to our prioritization and scheduling. So as a reminder, the three criteria that upon which the commission can deny without a hearing is if the applicant is challenging the conviction or sentence through court proceedings, so an active court challenge, the applicant has failed to exhaust all available state court remedies for challenging the conviction or sentence, or the commission determines that the matter should first be considered by the parole authority. Again, our summaries are not intended to be a recommendation. We've included minimal information on the summary sheet, but all of the documents are attached, and all of you should have received those at least 2 weeks ago. And again, the summaries are limited because we're balancing the need for you to have information for this process and staff capacity to analyze and condense the information. So what I'd like to do today is start with cases that people have identified that they would like to talk about. After that, if there is still additional time, we can go through cases based on which criteria they might meet and talk about them that way. Again, since this is a newer process, I encourage everyone to discuss thoroughly and think about policy reasons why something potentially should be denied without a hearing or not. So the first case that the name I received was case number 2, Daniel Anderson. And that one. Is based on it being a supervised release board case, so it's a life sentence. So would anybody like to discuss?
This is Commissioner Bad Harple. I apologize, I wasn't I wasn't able to attend the last training in person, but I did watch the video, which was really helpful, including walking through some of the example cases. So thank you for that. And it was helpful for me to start thinking about, for some of these cases, including this one where there is a review coming up, not necessarily super in the immediate. I mean, it's 7 years, about 7 years from now. And at the same time, recognizing the backlog of cases that we have. Just my curiosity, I'm still trying to wrap my head around if it's that far out, how likely, even if we were to keep it in the rotation, how likely are we to even hear it before that hearing comes up?
That's really hard to answer because as we get new applications, we reprioritize. So it would based on what we receive between now in the next few years. So we don't have the capacity to hear all of the cases, so they will move up and down. And if my staff has any other information from the spreadsheet about timing, I don't think this one rose to the top of the priority list.
That was my other question, was how likely would this be to be prioritized?
Executive Director Stark, could you just say a few words? I know we talked about it at the June hearing, but and staff also, just about what our current wait lists and backlogs look like again. Just because I'm not sure if we're live streaming right now, it's probably helpful for people to hear. Even just rough at this point, I think.
Yes, I just had that number.
It's okay, and I can make another comment as you look for that. Just generally for the summaries, one of the things I'm realizing, and I hate to add to workloads because I know, or request to add to workloads because I know it's you're working around the clock as it is. One thing that would be a little bit more helpful for me is just to have a little bit more in the background of the underlying offense, which would help me get a better sense of what I think other entities might see and might do when they look at the case. And you generally, all of you do a wonderful job of summarizing the underlying facts and the underlying documentation. But I'm realizing for these, technically, that's not what we're delving into. But when we think about how the supervised release board might respond, or when we think about just how another entity might treat one of these cases, and as much as we're all looking at rehabilitation and accountability and these various factors, I think we all do know that the underlying offense, whether it's an aiding and abetting or a felony murder case or a case with some other mitigating factors, might be looked at differently by other entities. So if it's possible to add a little bit, even just to, and we can find it, but just link to the complaint in some of these, that might be helpful. But the supervised release board, I think one thing to keep in mind is that, it may change in composition between now and 2033 in some important ways, because the members are politically appointed. I think now they still only got 6 of the 7 places appointed. And I know that it's a tremendous amount of work and it's hard to keep the entire commission filled. So it's hard to know whether or not the composition in 2033 will reflect what we're seeing now in terms of grants or not. I'd point out that, and I say this over and over again, the supervised release board is not reflective of the population of folks and demographically reflective of the population of people coming before it in the same way that this commission is. Again, that's not to make a qualitative observation about capacity to do what they need to do, but I continue to think that it's a really important thing that these entities reflect members of communities that are disproportionately impacted by the criminal legal system and by incarceration. And my hope is that the SRB will become more reflective. It's not currently. So I guess I see us as treating these cases differently at times. And so it's not I guess for me, it's not an easy, they've got a shot with the SRB, therefore it's equivalent. I know that doesn't help our backlog, but that's what I was going to say while you're pulling up the numbers.
Yeah, so we could.
Ineloquently, sorry, that was meandering.
So we have approximately 162 commutations pending, and that does not include ones that are already calendared, withdrew, are ineligible, and that we still have some to screen, so there might be a few more ineligible, but that's approximately how many pending applications we have.
Can you remind us how many we generally have the capacity to hear in a calendar year?
So it has changed. So last year we heard 19. This year so far we've heard, I think 3. And we're, after this meeting, we're going to figure out if we're going to hear more in October or not. I did some numbers to see if we heard the same percentage of commutations that we do of pardons. And in order to do that and keep the pardon numbers, we'd have to have, I think, 2 or 3 additional meetings per year, or reduce the amount of pardons. And part of the reality is just that the commutations take longer to hear because they're more serious cases.
This is Commissioner Crawford. One of the questions I had on this particular case was what they was asking for as far as the commutation relief for a sentence of 2nd degree. Commute my 1st degree unintentional conviction to a lesser 2nd degree and sentence me to 30 years, meaning I would still serve the 20-year sentence. And this is where I'll tap into my colleagues from more of a legal background of if that decision was made, what impact would that have as far as the date that was brought up by Commissioner Bad Harpo?
So if that change happened, it would reduce it from a life sentence, and it would be automatic. If it was a 30-year sentence, determinate, it would automatically be released at 20 years onto supervised release for an additional 10 years. Whereas with a life sentence, generally it's lifetime supervision once they are released. So looking at that date, that would mean release in approximately May of 2027, maybe earlier based on credit for time served in the original sentence.
Thank you for that clarification.
Well, my reaction, this is Commissioner Messrick, my reaction to reviewing this particular file was that there is, I guess because I am a lawyer, there is lots of prima facie evidence of rehabilitation and remorse and all of the factors that we look at. I couldn't get a good handle, as I think Commissioner Moriarty commented on, of the underlying facts of the case. And that was, and it was because it was charged by indictment.
Yeah.
It didn't have a probable cause statement, and that would have probably helped a lot. So
And just to be clear, that's not a reflection of what staff did or didn't do, just for those who are watching. It's just the availability of
Yeah,
the information.
and there's no bright line that defines this. And yet, on the other hand, I think the statutory purpose of this commission and what we are to look at is met in this case. I really don't, yes, he has a potential supervised release hearing in 7 years. But that's an awfully long time to incarcerate somebody who is shown that, or at least has made the case that he would not be a danger to the public, that he has rehabilitated, has an exit plan, et cetera. So based on those factors, I would be inclined to support allowing him to have a hearing.
And this is Commissioner Crawford. If I can add to that, understanding the need to take care of his elderly mother that has some challenges. It sounds like with both mental and other challenges since the parents are no longer together.
And I will note that there is a brief offense narrative on page 99 of the packet. It is, it's part of the DOC records. On each case, they have a 1-paragraph description. Of course, that does not give a good enough look of all of the facts and mitigating factors, but that's one place where it's listed. And I will say so for cases where the commission does not want to take action, like I said, it'll just go back on stay in the list. So we wouldn't need a motion or anything. I would just need to know when we want to move to the next case.
I'm happy to make a motion. I would move that we grant the request for a hearing. Is that what we need?
No, we don't need a motion.
We don't need a motion.
It's-
Okay.
So for these, it's either they are denied, or the recommendation is to deny without a hearing, or they will stay on the list.
Okay.
And we'll somehow keep track of the fact that we discussed it and it was not denied, so it will continue.
Okay. That. Rather than try and restate that, I'll say
Yes.
like the latter.
Yes.
Yeah, I would suggest that it stay on the list.
I agree.
Yeah, I agree too.
We need to call.
Nope. Basically, the commission's deciding not to take action on this case at this time. That's the decision. All right, the next name that I was given was Brian Batchelor, which is case number 3 for first-degree murder while committing aggravated robbery.
This is Commissioner Bad Harpole. This is obviously very, very different case, but similar in at least my analysis with a strong record of rehabilitation. And I came in with similar question as the previous case was discussed as far as this supervised release board, the fact that there's a review hearing coming up in 2029, which is sooner than the previous case we discussed. That being said, we've also had the conversation about, you know, what is the supervised release board looking at, and maybe how they review rehabilitation may be different from how we review rehabilitation. And that's where I guess I'm still struggling a little bit with my initial, I think, response was, well, here's one we could take off the list and deny it because he is going to be before the supervised release board relatively soon. I mean, I know it's not as soon as I'm sure he would like, but and at the same time, again, I go back to the case record and the strong record of rehabilitation. And is there a possibility of, with any of these, if we do deny it without a hearing, allowing them, like making some sort of a note in the record that they could come back or reapply without a waiting period? I'm just curious if there's other options.
Yes, so we because the commission will change over time, we can't have a note that says you can apply again before the 5 years has passed without a waiver. However, there can be directions to the next commission, whether it's the same or 5 years from, or 3 years from now, recommending that if a certain circumstance changes, they should apply for a permission to reapply early. And I think that is just, you can't, a future commission is not bound by that comment, but it will be in the record so the applicant has that to support why they're reapplying.
That's helpful. My other question is, and it's possible I missed it, which is why I want to ask. I didn't see anything that kind of rose to the level of thinking that this might be a case that would be prioritized. Is that correct?
So
If it were
this
left.
case has, I can see at least two prioritization factors. One of them being that I think this individual has been incarcerated for more than 20 years. And it looks like they were less than 25 at the time of the crime. So this would be slightly higher in the prioritization list. A lot of people meet those two factors, and then we have a group, and then we look in deeper to things like disciplinary history and supervised release board. However, I will say, if the release date or their first, we don't have a very specific way of determining prioritization in relation to supervised release board dates, because if they've been denied within the last year, we generally put them to the bottom of the list, because especially if it's the first time they've been in front of the supervised release board. We also are hesitant to schedule if they have one coming up in the next year. Because we've heard the board say, well, we want to hear what the supervised release board has to say, or they defer to the supervised release board for the release decision. So I don't know how those factors would, I don't think this case would go to the bottom of the list based on the fact that it's a first hearing.
Yeah, I hate to say it because I know part of it is trying to figure out how to, winnow our list to some degree, because the backlog is extreme, but it's just why we need to look at each case individually. I mean, the fact that it's been more than 20 years, the fact that I believe he was 19, I mean, the underlying offense is quite difficult, but the record of rehabilitation and the letters of support from a really broad range of people from a broad range of entities is pretty extraordinary. I mean, I'd be inclined to leave it on our list and not deny without a hearing at this point. again, I'm just concerned that I agree with Executive Director Stark that the board is likely to defer to the supervised release board if it's pending, if it's, I think we've seen enough to know that. But even 3 years in the future, I mean, because the appointees are, and I mean, I guess we're all appointed by political beings. But I do think the board may change more because it's the both majority and minority leaders of each party, plus the commissioner who will change as well. We just don't, the only thing we know is sort of our current practice at this point. And I guess I'd like Mr. Batchelor to retain the opportunity to come before us. That's what
I agree.
I agree as well.
Yes, I agree. And again, I'll lean on the fact that I'm not an attorney, and understanding how and why some of the charges were first degree versus second. In reading this, again, we're not retrying anything, but I don't know if the intent rose to the level in my mind's eye of, although it resulted in something very horrible.
Yes, absolutely right.
And the age of being 19 and his previous upbringing.
Commissioner Ruller, I agree as well.
All right, so that one will stay on the list for hearings. The next one is number 12, Michael Francis for first degree premeditated murder, attempted first degree premeditated murder, and contraband in the state threat. Sure, we can do that.
And Executive Director, I do have one question about Joseph Bergeron. It looks like there was a possible parole hearing on the 30th, and I may have missed it, but I was just wondering if we knew the outcome of that hearing.
As of today, we do. I'll let Zia answer your question.
Yeah, he did. He had his SRB hearing on the 30th of June, and they decided. So they said that they were denying release at the time, with the condition that he completes treatment and he can be seen within the next 12 months if he completes treatment.
Okay.
They mentioned that he's been reluctant to do so, so they're hoping that this will be motivation, because they said that if he, within those 12 months, if he hasn't completed treatment, then they'll do a 6-year continuance.
6 years.
Yeah, I think they were trying to really, they said like they want that stark difference to encourage him to complete the treatment. But if he does, then I think he can come back within a year to the SRB.
I mean, by statute, it's supposed to be within 3 years. Yeah, but okay.
And this was which case? I'm sorry, did we?
Bergeron.
Oh, and that was one, did I see that there was a note that, or there was a claim that the treatment was not available because he was too low risk?
Yeah, that's,
Yes, it did.
which doesn't make sense.
How can he do?
I mean,
Did you find it?
I'm looking at the case.
Yeah, where it says it's not.
I don't know if that's something that was addressed at the supervised release board.
This is Commissioner Mesrick. What is the likelihood that if he stayed on the list, that he would get a hearing within the next 12 months?
He's now been denied parole for 24 years,
Yeah.
over and over and over again. Is that?
he was released. And then because of a probation violation was
That's right.
reincarcerated.
That's right. That's right. That's right.
2014.
That's right.
Long time.
But the continued or the repeat reviews continue to note his lack of participation and lack of completion of chemical dependency.
That's what it is.
But then there's the note that the treatment isn't available because he's too low risk.
Right,
Mhm.
so,
So how do we
yeah.
look at that? Or is that something that maybe needs to come before this body?
Right.
I mean, the other thing I can do is I can get more information from the Department of Corrections on whether that is going to be available now that the Supervisor Release Board specifically ordered that.
That would be helpful.
That would be incredibly helpful. I
would.
really think my decision would hinge on whether or not that was the condition and it was available.
I agree.
But for the Commissioner Byrd, but for the short term, I mean, for our purposes today, I mean, I would recommend leaving them on the list.
Yeah. Agreed.
Agreed.
Mhm.
All right, and I have made a note to check in with the DOC to see if there's any additional information on that. All right, so the next one is now number 9, Joshua DeRozier.
And one of the reasons is Commissioner Byrd again. One of the reasons why I wanted to discuss this one was I thought this applicant, I mean, he's been in there a very long time, has a very good plan, which he's asking for a step down, which we've seen before. And, you know, there's just a lack of discipline incidents. It's not a question of like rehabilitation or even issues while he's been incarcerated. He's just asking for the opportunity to sort of get his ducks in a row, and you know, we don't usually see that. He's, you know, he's built a plan, he wants to work his plan and kind of work his way through, and I think that's you know, very admirable. And just the idea of that, I think, you know, for at least for me, I thought was very positive and a reason to keep him on the list.
And I do know this one is towards the top of the list as far as scheduling and prioritization. We did have it scheduled previously, but then the applicant withdrew and resubmitted a new application.
So I mean, he's got consecutive life sentences, right? So, I mean, realistically, I mean, he's not even eligible to begin his second life sentence at the very earliest until 2032. Which, I mean, realistically, he was about 20 at the time, I believe. I mean, that's a minimum of 60 years. That's an extraordinary amount of time. It's not to minimize, I mean, there are 2 victims here. That's not to minimize that. But, you know, one of the things that we're here to do is to take a second look when we have these sort of one size fits all consecutive sentences that are themselves an extraordinarily long amount of time. You know, it doesn't mean that, similar to the Adrian Raleigh case, it does not mean if we run things concurrently that someone has an outdate. They still go through the process, but I'll speak for myself. I think giving someone hope of release, and not dying in prison is an extraordinarily important thing. And that's, I think, endemic to clemency and mercy. So, I would suggest that he stay on the list. An SRB date in 2032 for the first of 2 consecutive sentences is not meaningful in terms of release, frankly. So.
All right, if there's no further discussion on that one, I can go to the next one that I've been told someone wants to talk about, or you all can bring up which cases you want to talk about. The next one I have is number 12, Michael Francis.
This is Commissioner Byrd. One of the reasons why I wanted to discuss this one was that the applicant had offered 3 alternatives as part of his commutation request. And I thought that alternative 3 that he listed was, for lack of a better term, reasonable. Considering, and I didn't know if anybody else felt similar.
Yes, and I felt him discovering, as he put it, his different personalities and thinking on how he got to the place where he is. And of course, the age he was at the time of the offense and the time served.
I was just pulling up the relief being sought, and Commissioner Burt, you mentioned number 3, which would be to have 3 consecutive sentences run concurrently and reduce the 38-year sentence with an executed prison sentence of 25 years and 4 months. So yeah, I mean, that would still be up for consideration if the board or the commission decides not to take action today.
And that was just my consideration, was the idea of staying on the list. So we could have that more robust kind of conversation about it.
I would agree.
All right, the next one that I have is number 16, Michael Hall. So this one is first degree murder premeditated with a conviction date in 2007, parole eligibility date of 2037.
27-year review will be 2034.
Yes.
I think for me, this is Commissioner Crawford, for me, not to downplay what happened, but there was an ongoing situation there that I don't know how much light was shed on what happened with previous threats back and forth. And I'm not sure. Again, I struggle with what some of these folks are being charged with versus what happened. For me, first degree shows clear intent. Plan to do this. Second degree does not. Yeah, this was a horrible situation. But I think the history, the back and forth that was happening that led up to this horrible event. And of course, the time served. And I don't know, did they talk about the mental state at all? I know that they were experiencing homelessness.
So, yeah.
So I don't know if there was chemical dependency or anything going on as well. And I'll pause there. Yeah, I think it's it. Experiencing homelessness for over a year.
Yeah, and I also note that I think when you look at his own writings, and he's had a lot of time to self-reflect. I mean, his first 200 days in prison were in segregation, which, I mean, I can't imagine six plus months.
No.
Being forced to deal with yourself off the shock of that. You know, and at that age of the occurrence, I think it's definitely a case that I would be very willing to support staying on the list.
I would too. The other thing I'm noting from a lot of these first degree premeditated cases is I've been looking at Judge Meserick here. I mean, they're paying trial penalties in almost all of these cases. So I mean, they're charged, and this is Ramsey. And yep, Hennepin County has changed its policy in the past several years, as Commissioner Byrd, I'm sure knows, where you don't just charge first degree premeditated because you can, because you'll force a plea to a second degree intentional. That doesn't happen to the same degree anymore. It certainly did then. This was Ramsey, and I do think, and it's Ramsey 20 years ago. And yeah, I mean, premeditation under our law, under our case law, can be instantaneous. The interpretation of premeditation is certainly not what I teach to my criminal law students. And there's, deliberations not required. So you get the conviction, and depending on the nature of it, it can be mandatory life without. So you're facing that in a lot of these situations too. And yeah, he was convicted by a jury, but I guarantee, I'm pretty sure he was offered a plea to second degree somewhere along there. Do you agree with that?
I
Judge
do.
Messer?
I think that was a very common practice.
Yeah. And it still is in a lot of counties in the state. In fact, almost all of them. I think Hennepin has revisited that. Ramsey periodically does, depending on the nature of it. So, and again, this isn't to minimize the harm. I feel like our role is to revisit practices that had a disproportionate impact on folks who, again, we don't know the underlying circumstances, but I'll also say, at least in my research, there are I'll say the upcharge and the trial penalty is disproportionately paid by defendants of color in Minnesota in particular. And that's, I feel like our role here is to take a second look when and circumstances reveal significant rehabilitation Yeah, I know this isn't helping with our backlog, but
No, it isn't, but
Is-
But I think
I
it's
look
a-
at the irony of the
Yeah.
number of times that we tell people they have the right.
yes,
You have the
Mhm.
right, you have the right to a jury trial. And then we penalize them for exercising that right. So absolutely, I hear you.
So I'd like it to make it clear, this is not intended to, like, this won't fix the backlog. It's not
No, it's not.
intended to. It's a part of the statute we haven't really used. And so we thought we should go through this and consider whether there are some.
And
So
I know, I know no one's looking for denials without a hearing. All I'm saying is that to the extent we had an opportunity through this mechanism to the extent we had an opportunity through this mechanism to refine our list, I think what we're finding is that it's probably not a mechanism we're that comfortable using in a lot of cases. And I know all of you probably feel the same way. So. I was also hoping to look at Al-Shabazz at some point, but again, I realized I didn't give you advance notice of that.
that's okay. We can
go back.
go back to that one. That one is number 1.
So my question here was on the sub 3 is the felony murder provision. And one thing that I just want us to discuss this more generally. I mean, I think all of us know about the amendments to the aiding and abetting law that allow folks to go back under first degree if no intent to kill. I mean, there's some requirements there, and then under second degree, it's the major participant inquiry. Problem is that window closes. I believe, and we talked about this with Catherine Middlebrook when she visited in May, I think it was. I think it's been extended for a year, but I think there's a statutory window within which applicants have to go back and seek relief under the aiding and abetting amendments. And so even though technically there might be a judicial pathway for those convicted of felony murder, I'm wondering if we should be at least aware internally of when that window closes and put that on our own calendar. I mean, nobody's going to have that pathway after a certain date.
I
And
think
of
that's
course,
an
I'm
excellent point.
forgetting when that is as we sit here, but I know that I believe it's been extended a year. I also would say, there are all these post-conviction second look mechanisms that were created in 2023. And a lot of them just are not yielding relief. Prosecutor initiated resentencing has been initiated in some cases. A Hennepin County District Court judge just found, even though the piece of law, the prosecutor initiated resentencing law says, notwithstanding any other law to the contrary, courts have the ability to revisit sentences when, prosecutors apply on behalf of someone. And there's, by a preponderance of the evidence, there's reason to think that the sentence should be adjusted. The district court judge, Judge Hoyos, just found that the law actually doesn't give judges any ability to revisit mandatory sentences, even though the piece of law says notwithstanding any other law to the contrary. So that is now, it's Hennepin County has only sought, I believe, prosecutor initiated sentence adjustment in 4 cases, and judges are declining to act in a number of them. We've also found that judges across the state are being pretty tough on the felony murder provisions. I think we saw in here when we were looking at cases with Catherine Middlebrook that in some cases, judges and counties are denying the applications without hearings, contrary to the statute, and then they're being sent back. So there has been a backlash against what I think was a pretty clear legislative intent to provide second look for sentences that were born of a period when we, as a society, were pretty harsh and pretty automatic. So even though these mechanisms exist, I do think the other thing to keep in mind is they may not be meaningful. And I think we're finding that they're not meaningful, particularly outstate, but even here. So sorry to say all that, but it's what we're seeing. So for Al-Shabazz, I mean, I guess, you know, he is someone else that, given the felony murder piece, I mean, conviction date, we're now looking at sentenced to life in prison. He's now been in for 34 years.
Yeah.
I was gonna say he's older, but I'm realizing he's younger than I am. But yeah, we're getting older. But yeah, I mean, he's 55. You know, the supervised release board just denied again for lack of demonstrated rehabilitation, the seriousness of the offense and public safety, et cetera, and continued his case for 30 months, so 2.5 years. I don't know. I'd be inclined to leave him on the list, but again, I mean, the pardon board might say, I think he's back before the supervised release board in 2027. Realistically, we probably won't hear it before then.
I think that was the primary reason I
Didn't cite it. Yeah,
didn't cite it.
I just wanted to raise the felony murder piece. One last comment on felony murder, sorry. That, you know, you're not entitled to court-appointed counsel in these cases, and it's really hard to navigate the aiding and abetting law and its permutations without legal advice. And, you know, I think that's just not available to a lot of people.
I don't know if this was already answered. The deadline is either October this year or October next year for filing those cases.
Yeah.
I think it might be this year.
I want to say it was initially last October and they extended it to this one.
Sure.
Yeah.
I think that's. Yeah.
Are there other cases that you or others saw that had similar considerations related to aiding and abetting felony murder that we want to sort of look
Yes.
at?
I have 18, wasn't it?
Yes, I was thinking Keith
Henderson.
Henderson.
Number 18. This is Commissioner Byrd. In the case of number 18, I know that it had been the time since conviction, and you know, the change in the law, how we approach these. Plus, I know that the Hennepin County office,
This is the PISA case.
yeah,
Right.
it's one of the PISA cases.
What is that by definition?
The PISA?
Yeah.
Oh, the prosecutor initiated sentencing adjustment. They, based upon how they're approaching it, and also his rehabilitation, they moved to change his sentence to, I believe it was,
Concurrent.
yeah, moved him to concurrent instead of consecutive, which would make him, I believe, eligible in, is it 2 years? I can't pull it up.
I can pull it up in Mensis, actually.
Sorry,
I've
yeah.
had it before. This is one of the cases, this is one of only 4 cases that Hennepin's chosen to bring.
Mhm.
And I mean, to bring it means that they've found extraordinary, I mean, they've combed through absolutely everything. I've gotten their file in one of the cases because we're bringing one ourselves.
Mhm.
And it's thousands and thousands of pages that they've been through. And so to move on one of these applications means that it's pretty darn compelling.
Mhm.
But what's, the difficulty is that depending on the judge, they may or may not be amenable to actually acting under the statute. So I can,
Well, and this is one where conditional parole was granted, but there's a consecutive 5-year sentence.
Right.
So the prosecutor initiated sentencing adjustment would, I think,
run that concurrently.
concurrently.
Yeah.
Because the parole board made a comment that if it wasn't for that, I think they'd
They'd
support
release him.
release.
Yeah.
Mhm.
Was that the gang enhancement?
I believe so. And there was a hearing on this one.
Yeah.
And it looks like it's under advisement still.
Are you looking,
I'm looking at what was submitted by.
I'm gonna look in Mensis right now.
Yeah. And the judge is Lisa Jansen.
I would just say, considering that, I would recommend, or I would be in favor of leaving him on the list pending. Because, that could change.
Yeah. I would as well. Commissioner Mesrick.
This is Commissioner Crawford. The only other one I saw that was close to that, and again, my colleagues, you all can help with that, was number 30.
Number 30, Meng Vang.
Yes. And again, what struck me was the age at the time and the work that they have put in. I thought some of the letters of support was pretty convincing from many different folks in community and in recovery.
So I'll also note in the parole eligibility date and disposition. So this one, the sentence was 2 consecutive life sentences and a consecutive 186-month sentences. So there's a parole eligibility date, February 3rd of 2035, but I believe that's only the first life sentence. So then there would be the second life sentence and then an additional 186 months.
I mean, let's be real, that's death in prison. So. I guess I'll just go out and say, for people that are, and it is, again, it's not to minimize the harm in some of these cases, and, you know, generally consecutive life sentences involve 2 deaths, which is an extraordinarily horrible thing. I personally would support review of any case where someone is sentenced to die in prison.
We are looking at scheduling to life without the possibility of parole commutations later this year. Based on some of the discussions that happened in the Court of Pardons, especially given these 2 cases that we're going to schedule were not discretionary sentences, so they were mandated life without parole.
There are several provisions of the first degree murder statute, 185, that mandate life without parole. And, you know, I have a client who had mandatory life without parole and was 18 years and 7 days old at the time. And we actually did go back to court with the AG's office to amend it to life, because they were uncomfortable with it. So I think, I mean, we are yet another opportunity to review those.
All right, so I'm hearing that one or the commission would like to treat similarly and leave it on the list. Similarly to other cases.
I was gonna say, I would recommend that this one, or I would be in support of this one being left on the list. But I did have another one that I wanted to go back to. Number 26.
So that's John Quick.
Yeah, this is simply due to some of the medical concerns of this applicant. Also, just the idea that with this applicant, his initial parole eligibility date is until 2030. Some pretty serious, appears to be pretty serious health concerns, and not able to address that completely. Being within.
Commissioner was diabetes.
Yes.
Okay. And it seems like at the facility, they don't have what they need.
Yeah.
How is that typically addressed if someone, are they moved to another facility or?
Yeah, that's what I'm,
Yeah.
that's what part I don't know.
Yeah, they definitely can be. I mean, there's some DOC facilities that have greater access to it. And I know Oak Park Heights does, but it's the most severe facility. I believe Faribault has a medical wing, but the difficulty is just managing a chronic illness in general population. I mean, it would be treated. I mean, he would certainly have access to insulin, but it's much harder. There are dietary restrictions. I mean, all these things. So.
Yeah, I mean, trying to stay in my lane here,
Yeah,
but
yeah.
that seems like that would fall under human rights or whatever
So
issue.
they don't. I mean, Carly can speak to Executive Director Stark can speak to this. Question is whether the disease can be treated, you know, in some way within the facility. This is sort of the inquiry for expedited review from the pardon board. And most chronic diseases, I think they take the position that they can be. You know, I'd submit not always well.
Well, as I looked at it, this is Commissioner Mesrick, a hearing would flesh out that issue, at least help us. And, this is an area that my term as a commissioner has greatly concerned me because they're medical conditions that can be treated and, in, the custody of the Commissioner of Corrections, but chronic conditions are very difficult, and this is pretty serious. So I would favor leaving it on.
I mean, we just had one, I know, within the last year that someone had a very serious surgery and wasn't safe for them to be in the general population because of that. So I think this would fall, for me at least, to have a hearing, but it also falls under that that human rights umbrella of.
Agree.
I think someone else also mentioned they wanted to review number 25, Clinton Omoya.
Now I gotta remember why.
He had a pretty strong record related to rehabilitation, great letters of support, extensive remorse. Yeah, I had the concern that one, again, that we may not see him before the supervised release board, but either way, I would be in favor of keeping him on. To give him the opportunity.
So one thing I will note about this is actually a determinate sentence. And the ground presented is that the applicant is challenging the conviction in state court.
Right now.
Yeah.
Related to
That's
accomplice liability. So the September 5th, 2028 date is it like, unless there's a discipline issue, it's a hard out
Hard
date.
out date.
Okay,
And I don't think we'd actually get to it before then.
No.
we probably wouldn't.
So I think it's maybe the only case where this may be the only case where I think denial without a hearing would make sense, actually, given that there's a defined out date prior to the date when we would hear it.
As long as there's no discipline issues in the.
Usually, I mean, I don't know, but usually unless there's significant discipline, the 2/3 release, it's rare that it's extended unless there's an actual criminal offense on the inside.
Carly, this is Commissioner Director Stark. This is Commissioner Mesrick. What what are the applicants told, who fall into this bucket of cases when we deny review?
So we would tell them that the commission reviewed their case and has recommended to the board that they deny the case without a hearing based on, in this case, it would be because the applicant is currently challenging the conviction in state court. And if there are any other notes or comments that the commission wants to put on the voting form, we would talk about it and we could put those comments down there.
Okay, that sounds good.
Commissioner Burt, were there any other applications that anyone wanted to discuss?
I was interested in discussing Ronald Reed. This is one, well, I'll just say I'm in favor of keeping it in the rotation. I know, the seriousness of the crime. It was a police officer who was killed in 1970. I believe Mr. Reed was 19 at the time. My understanding is he wasn't charged until 2005. And within that time had 20 years of being law abiding prior to incarceration, involved in recovery groups. The main thing I just wanted to discuss is the fact that he continues to claim innocence, and the fact that, he has, reviews, he's had reviews, he has more reviews coming up, but that continues to seem to be a barrier. The desire for him to admit guilt. And then, so for that reason, I would like to hear, if that continues to be a barrier, I would really like us to have the opportunity to hear his case. And also prioritization due to his age, I think is important. He has excellent letters of support.
Yeah, he's 75.
75, this is one of those cases where I recognize we can't relitigate and determine innocence, but there are so many other factors here that I feel like he's deserving of that time if we can give it to him.
All right, a quick question. Did we want to vote on Clinton Omoya's application? Because if so, there would need to be a motion and a full vote to recommend a denial without a hearing. And we can wait and do the votes at the end if people want to continue talking through.
Say, wait for people to come.
So what would be, this is Commissioner Crawford, what would be the implications or if we move forward versus letting it stay the course that it's on right now?
If you were to grant denial without a hearing and the board agreed with the decision and denied it, there would be a 5-year waiting period, at which point the sentence, I don't have his up anymore, but the sentence would be very close to expiration. So he would be out of prison and his close to being off of supervision. If it stayed on the list, it would probably continue to be deprioritized because his release date is in 2028.
Yeah, September.
And then at that time, assuming he were to be released, obviously it automatically drops off.
It wouldn't until his expiration date, because as long as the sentence is active, people remain on the list. We would reach out to ask if they still want to continue with the case. We don't do that every time we find out someone is released, but we do monitor and update release dates because it really impacts who we schedule.
Okay, thank you.
One question is whether, I mean, it shouldn't, but whether denial without a hearing would be viewed by another entity as a qualitative decision by us. It shouldn't be, and especially if we're saying it's about exhaustion of state remedies. I think that was an issue in his case, as is a certain eligibility date, but that's just an open question. I mean, I do think even if it's not a decision on the merits, I think it's interpreted that way by applicants at times and potentially by other entities. I don't know what people think about that.
In this case, are you concerned about the court's a view of it, or?
No, I guess if there's any, I think I don't, I'm trying to remember what that remedy would be in court here. Is it an aiding and abetting remedy? Well, I mean, it, it shouldn't, affect a judge's review of the merits. I think I was more thinking about DOC, and I guess it's less of an issue with a determinate sentence.
Oh.
So maybe more just the applicant. And maybe it would be just a matter of putting language in the letter emphasizing that it's not a denial based on the merits of the application. I mean, even though that's obvious when we're saying that it's, you know, for one of these other reasons, can we, I mean, how do you feel about that, Executive Director Stark?
So legally, it's considered a denial on the merits because that's what, and there's a statutory reference to this specific type of denial. That doesn't mean you can't add language indicating this is not based on, this is based solely on.
Procedural posture.
Yeah,
the
I
court
guess I'd
challenge.
be in favor of adding that language to the extent it's consistent with the statute.
Mhm.
Right, so it doesn't get looked at.
By the applicant as well, like, I think
Yeah.
that's an
Yeah.
important piece.
I agree.
And leaving it on the list. Would that be favorable or not?
Well, in terms of the court, I don't even think the court would know.
That's right.
Okay.
And this is pending in federal district court, isn't it? Is it not? Or is it in state court?
It was state court. What we've thought about related to this provision is well, one, it's a hard balance, but we've thought about, is an answer of a denial better than waiting for years without an answer? And I think the answer is yes and no, depending on the case. One thing we've run into is people calling to figure out when they're going to get a hearing because we talk about what we prioritize, but so many people meet some of the prioritization criteria that a lot of it is based on one case meets 3 of 6 and another meets 4 of 6. And so it's constantly moving the target. And again, nothing we do here today is going to change the fact that we
Mhm.
have a backlog that can only be fixed through legislation and more resources. We are considering, I think I mentioned this in the last meeting, but I want the screening committee to get back together so we can go through applications and sort of have them help us again with prioritization. So the screening committee, as a reminder, since it's been a while since we've talked about it, is Commissioner Moriarty, Commissioner Graves, and Commissioner Lindstrom. My hope would be to do that this fall before the end of the year.
I will just add that we do have applicants on our commutation lists where their sentences do expire before we ever get to even the possibility of a hearing. So that's not, like, this wouldn't be the only case. And then just maybe thinking about, is it truly about the active challenge? Or is it the combination of active plus this other factor? Just posing that question.
Yeah. I guess for applicants with determinate sentences that are due to expire prior to a hearing, it does seem to, I mean, those seem to be cases in which we might use the denial without a hearing, as long as we were able to put, from my perspective, language in there that makes it clear that the expiration of the sentence, I mean, effectively, you know, I mean, I suppose we could commute the probationary term in some way, but it's unlikely that the board would support that. So I would suggest that those might be cases where it is actually provides clarity to the applicant. As opposed to leaving it hanging out there in ambiguity if we know they're not going to get the hearing in time.
I'm wondering, Commissioner Bad Hartful, if there's any others, I'm going through the list here that have existing supervised release dates on the list that we're currently, that we should be looking at to see, are there any other factors for some of the other cases? One that I see is Elijah Millsap, I think has a supervised release date of 2033. He makes some procedural claims, I think, which have been denied in the past. Go back and look. But I'm curious, is this another one? I mean, this one, the supervised release date is a little bit further out. But at the same time, one, how likely are we to hear them? And if they have a date coming up? Is that one we would want to deny as well?
I mean, the other thing I'd point out about this case is that it's a determinate outdate that's part of a plea. And so it's a sex trafficking. I mean, I'm just thinking also about what's likely to happen if we were to hear it with the parole board. He's been in for less than 10 years pursuant to a agreed upon sentence that's part of a plea where multiple counts of felony sex trafficking were dismissed. And there's an agreement to run this as part of the plea to run the sentences concurrently. And the procedural issues, the main issue raised is excessive sentence, except that it was an agreed upon sentence. So I'm just looking at this and thinking it's almost impossible that he would be granted relief by the pardon board.
Well, and also just looking at the application, I don't see anything that demonstrates a statutory reason.
I'll just remind everyone that, I mean, the only reasons that it can be denied are those 3 statutory reasons. And this one is listed because I think he made an ineffective assistance of counsel claim and maybe one other that he,
Excessive sentence.
yeah.
Pending, yeah.
So those are potentially remedies that have not been exhausted, and also the commission and board generally will not determine issues like whether counsel was ineffective.
We are not addressing legal issues presented in these cases.
So this might not fall, I mean, what we just articulated might not fall within the statutory reasons for denial without a hearing, but there are reasons for deprioritization. So it seems to me that this may remain on our list, but the screening committee can look at it for those other reasons.
We'll say the same for 22, John Mark. He has a full eligibility date of September 1st of this year. And his procedural issues was based upon disproportionate sentence compared to his co-defendant. And it's something we can't adjudicate that.
So I do think when it's a trial penalty, which it looks like it is here, it's it's he was sentenced to life. I mean, what will often happen is when it's an aiding and abetting as well, there'll be, I mean, at least in my experience, there'll be a plea offer to the principal who to testify against the accomplice, who then often goes to trial. And so you frequently have, and it's the case in one of our clients, the person who, you know, did not commit the crime is serving a much more severe sentence than the person who did. Again, they're both aiding and abetting, but because the plea offer, there wasn't a plea offer, or it was a harsh plea offer to the aider and abetter, they went to trial, convicted of first degree, life or life without, and then the actual shooter, in some cases, then pleads to second degree. So it is possible that you can have sentences that are disproportionate in this way, but parole eligibility date, I think that's just the 20, would that be the 27-year review? If it's a life sentence?
Yes.
Okay. So eligibility would actually be 2029. Release eligibility would.
Three years later.
Yeah, so 27-year review is this fall. I mean, the 27-year review is, you know, generally this is what you should do in the next 3 years. It's not a meaningful outdate.
One question I have about this for the commission to think about is related to the commission should act independently, but I know it's impossible to not think about how the board may treat a case. So if the commission were to review this and recommend a grant, the board would then likely send it back to the supervised release board. So I think, not this case particular, but in cases where their 27-year review is coming up soon. Is that something that the commission wants to see happen and be resolved, or before hearing the case?
But if we left him on the list, that would happen. I mean, that's happening in September, right? It's still not clear to me that it's, so the basis for denial without a hearing would be number 3, should first be considered by the parole authority. I mean, we're at a 30-year review. I mean, a 27-year review, we know that he's not getting out, right? So I mean, it's possible that, I mean, the parole board doesn't have discretion to let him out in advance of 30 years, but say there's a 27-year review in September where they say, you know, he's an exceptional candidate. He's done everything he possibly could. It's an aiding and abetting case, et cetera, et cetera. There's a trial penalty. And then we decide we're able to hear him, you know, in 2027 or 2028, realistically. I mean, I do think our grant and the commutation grant by the parole board, even if he were to go back at his 30-year review, would be meaningful for the supervised release board's consideration. So I guess I would favor leaving him on the list. But
And Chair, I had a point of order as well. We were talking about Reed at one point, and I don't think we made a decision.
Read?
Yes.
Yes.
oh yeah,
I believe that's number 27.
Mhm. Yeah, that was the one where he continues to claim innocence. And that's been a hindrance to him at the review level.
Mhm.
He also has the factor of his age.
His years of
Absolutely stay on the
recovery,
list.
years
This
lost.
is strange.
It's a very unusual circumstance.
Mhm.
And I
Yeah,
think
there's a lot going on there, as well as the other person who has been out for over a decade.
Yeah.
Mhm.
I'd be inclined to leave it on the list.
Would too.
Yeah.
I agree.
I'd actually be inclined to prioritize it,
As well.
but that's the screening committee.
The supervised
Yes,
release board
and-
meeting. If he has the same issue that he's been having with the innocence claim in August 2026. And he's what, 75?
Yeah, I mean, I'm also looking at the reference and this write-up is excellent, like the summary of Thiesen's dissent. Is really helpful to see. Because, I mean, so many of these post-conviction innocence claims are time barred. They're not decisions on the substantive merits, and Thiessen says that he should have gotten an evidentiary hearing based on his request for a new trial because there's recantation of critical witness
Mhm.
testimony. I mean, that's the type of thing that can be procedurally barred, that is incredibly meaningful.
Mhm.
So,
Yeah, and I will, oh, go ahead, Zia.
Sorry, it's just on Martin. Did we come to a decision on Martin?
It's going to stay on the list, and I think we
Okay.
clarified that that was the 27-year review date.
His
not-
27-year review, no, it was in 2023. He has appeared before the supervised release board already.
Okay.
Sorry, there was an error in the summary.
Oh, okay.
So he appeared before the SRB in 2023 and they continued it for 3 years. So I think the October 13th, 2026 is going to be his second review. If that makes a difference, but I just wanted to put that on the record.
is the conviction date?
Everything else is correct. It's just that he has already had his 27-year review. So
The math
That's
doesn't.
credit. You have credit for time served then, if we got to 27.
what do you mean?
He was convicted in 99.
I would still support leaving him on the list. I'm sure it's not a surprise.
And in that case, we would check the supervised release hearing results and release board hearing results. We probably wouldn't schedule it. Even if it was in early 2027, we likely wouldn't schedule him because we would want to see whether he is released by the supervised release board at the 30-year one. And then if he was not, or he was, that would change the factors. May I-
So, Jason Williams.
Right, Jason Williams. And then after that, I wonder if we want to look at some of the cases that have an active court challenge, and that's the only criteria, because we have some of those separated into
Okay.
a list.
So Jason Williams is a really complicated case in that. So when the supervised release board was created in 2023, there was a year prior to the board actually coming together in 2024. They were still forming it, where the commissioner heard cases under the new juvenile provision of the supervised release board legislation. And during that year, the 3-year mandated review period was not part of the legislation. And so Jason Williams is someone who was heard by the commissioner in that year period. Again, wasn't the full board. And the commissioner denied parole and said, come back in 10 years. Because there was not the 3-year period then was put in legislation in 2024. And Jason Williams was 16 at the time of his underlying. And again, not minimizing the harm. But I think that's an incredibly important piece. So there's no ability to change that tenure. That happened in a couple cases. It also happened in the case of a young person who was 15 at the time, named Kim Oak. And I believe that was a comeback in 10 years as well. And he's been in over 30 years. So I don't know where this falls. I mean, technically, he'll be before the supervised release board again. His parole eligibility date is 2052, at which point he will have been in prison for 60 years. Was 16 years old. I'd say not only leave him on the list, but screening committee.
And the reason we briefly discussed the idea of whether in reading these cases, the commission would want to say, let's prioritize this one. I think a different level of review needs to happen
Yes,
at the screening
that's-
committee
yep.
because this isn't all of the cases we have.
Exactly.
So
Exactly.
if you end up not seeing this one, it might be because there was another one.
I mean, he's 50, he's been in 34 years. Went in at 16. A note for the screening committee. On which I said.
So if the commission is okay with a suggestion of the next case, we talk about, we have 3 cases that have an active court challenge. We already talked a little bit about Clinton Omoya, Matthew Lupke, and Milton Sanders. So Matthew Lupke is incarcerated on a harassment restraining order violation. His conviction date was September 30th, 2025. The supervised release date is November 17th, 2026. Sentence expiration date is November 17th, 2027, at which point he wouldn't be eligible for a commutation. He has another file with similar dates. He filed a motion for correction of his sentence, and the matter is currently under advisement by the courts. So he just filed that motion on June 5th.
It looks like since the time the summary was written, the motion has since been granted. And so they did grant his motion to correct the sentence. So he'll be out 4 months sooner. So for the 1085 case file, he'll be out in July 2027. Which also means there's no active case filing.
All right.
Straightforward.
All right, Milton Sanders. Which is a first-degree murder, attempted first-degree murder, conviction date of 1998. On June 4th, Mr. Sanders filed a pro se motion for post-conviction relief, seeking to correct his sentence, asking the court to vacate 2 consecutive sentences. He's been granted provisional parole on October 5th, 2027. So he's already had his 27-year review. And provided he complies with the conditions, I believe he would be released in October 27th.
Woody, or I think he has a consecutive. Doesn't he have a consecutive sentence to run after that?
Yes,
Yes.
thank you.
So I think this may be one of those cases where the supervised release board has no ability to affect that next sentence, similar to the gang enhancement on the other case we discussed. So we may be the only body that could change that. What I'm actually wondering, and this would be a conversation for the screening committee, but if there are cases where it's clear that the supervised release board has sort of said, you know, our hands are tied. And have already evaluated the merits, rehabilitation, et cetera. If we have some ability to hear those more quickly, I mean, you know, not even just in terms of time, but if the proceedings themselves might be less, well, I don't know. I mean, it will depend if they're survivors or victims that come forward, et cetera. But I'm just thinking out loud about when we're getting messages from, so in the PISA application, that the Keith Henderson case, right, where the prosecutors have said qualitatively, this is a case where everyone agrees this person needs relief, and the court is saying, my hands are tied by the statute, which I don't agree with, but similar in this case where, I mean, provisional release on that first sentence at a 27-year review, we'd have to read a lot more, but I don't know if we're thinking about the possibility of doing, you know, multiple commutations in a day where we might have, usually they take about an hour each, if not more, where we have any ability to streamline some of them. That's just an open thought. Probably not, but.
I have about 6 thoughts trying to decide which one wants to
I can
be
tell,
shared.
I can see them wearing.
What I'm hearing is that perhaps we want to further define our prioritization criteria with the screening committee now that we have some mini summaries, so to speak. Because we have some criteria, but none of it is very, we have some objective criteria that gets things into broad categories, and then it's very case specific because everyone is different. So I'm open to ideas. If there are more cases we want to talk about, we can keep going.
This is Commissioner Crawford. So the one for Milton Sanders, that question was he has, is it an appeal or he's challenging something in court? Which would need a special vote for us to leave him on the list?
Nothing needs a vote if we are not denying without a
Okay.
hearing.
Okay. But that challenge, would that still make him eligible to have a hearing?
Yes, so this is completely discretionary. So if
Okay.
the commission decides to overlook an active court challenge or is not interested in seeing the result of it, the hearing can go forward.
Okay.
An example of that was the Brian Pippett case, because there was still ongoing state court matters. However, there were also, in addition to his innocence claim, health issues and a long history of rehabilitation and no discipline.
Yeah, I would like to see the Moulton case stay on.
I agree. Commissioner Moriarty, I have a question that relates to some of this discussion. Is the Hennepin County case being challenged? One that,
Yes, the decision on PISA. Yes, through a motion for pending motion for reconsideration last time I looked, but
Yeah.
how often do judges grant those? Sometimes.
And was there any kind of legislative intent argument or anything like?
And I think, I mean, yes, in the motion for reconsideration, yes. I mean, there's a lot of commentary on the record. I mean, the author of the bill was Representative Mueller. And in DOC, Commissioner Schnell provided testimony in support as well. I mean, everyone believed, at least at the time, that, and all the testimony supported the idea that the intent of the law and the language, notwithstanding any other law to the contrary, was really clear, that it was to allow, I thought, courts the ability to alter mandatory sentences when all the other criteria were satisfied. The language also says adjust a sentence in any way. So, I mean, I'm not quite, the interpretation by Judge Hoyos was surprising to me. I'll say that.
Anyone inclined to certify it or try and seek certification?
I don't know.
Important and doubtful?
Yeah, I don't know.
Okay.
Yeah. Yeah. I do know that Judge Scoggin also is screening all the cases and issued an opinion in another case saying that just sua sponte had concerns about the law from separation of powers standpoint, which is surprising to me since the legislature is creating a statute to allow judicial discretion to revisit its own legislation when the executive branch sees fit. So I'm not fully understanding that either. And these are pretty rare cases, so.
So Commissioner Crawford, I have a question about the aiding and abetting. If that continuance is going to sunset in October, what are the chances it's going to be continued is one question. And number two, are there cases that we should be looking at under that parameter because that window may close?
I can't answer the first question. I don't know if it is likely to be continued or not. I have actually got a data request from a legislator related to how many of those cases that we have received. So I'm pulling that data and it will be available for us to decide if we want to focus on that once that window has closed for those applicants or before. One thing I've noticed with aiding and abetting cases is they don't all fit very specifically into the statute that relates to our statute, because we have one that it waives the time period for a pardon, so they don't have to wait that 5 years. The other one is just that it's a factor for consideration for a commutation, but it's often the wrong subdivision or something like that, so they don't fit cleanly into that form of relief.
So the window really is about folks who are already serving their sentences and are seeking either, mostly are incarcerated and are seeking relief. Prospectively, the standard is now changed. So, presumably people arrested and charged going forward will receive the benefit of the law. The law allows people who fit within allows people to who are charged with aiding and abetting, first and second degree felony murder to go back to the county in question, and to apply essentially for a court to sort of screen and grant a hearing. And if successful, the conviction can be vacated and they can be resentenced under the predicate felony. I mean, it's a pretty remarkable, and just full disclosure, I helped draft it. And I think we would all say it's not that well drafted. It's kind of confusing. There was a task force put together by the legislature, and a number of us were on it. So it's a cumbersome law, and the problem is, I know for the public defender, the state public defender, just making sure everyone who's eligible has counsel. And I mean, there's been an effort to go through and find people before the window closes. But the other piece of it is that there are a lot of people who were charged with first degree, aiding and abetting, first degree felony murder, who then pled out to second degree intentional because they were facing a life sentence. And I mean, my friend, and some of you know him, Kevin Reese, is one of them, as is his wife, Jamesia Donnerson. And, they would not be charged necessarily with first degree now under the new law, but there are people serving second degree intentional murder convictions in prison and who are out who aren't necessarily eligible then, because it's not a felony murder conviction. So those are cases that I think are important for us to weigh the law change now. People who are, potentially in for 25, who pled out, who might have been just merely present or close to merely present, and yet were charged, but that they wouldn't be affected under the closing window. So I don't know how we find cases under the closing window. I mean, if they're in front of us and claiming mitigating factors based on aiding and abetting, but haven't gone to court, it could also be that, they don't have counsel, or they don't qualify for the state public defender, but also can't afford private counsel. Just thinking out loud. But it is good to weed them out for sure. It's a super it sounds like relief, but it's not necessarily meaningful and easy relief. And some counties hate the law and have challenged it on a bunch of different bases and judges aren't granting relief at all. So
We had one case that pops up for me. The person was convicted of aiding and abetting, and they were there. Clearly just there.
Yes.
And didn't know what was going to go on. And it went down, and they did plead because of that fear of being, of having a life sentence. And now because they accepted that plea, they wouldn't be eligible to go back and challenge.
Last thing I'll say on this, we just did a study of murder convictions in Minnesota from 2010 to 2020. And, over 70% of murder charges and convictions in Minnesota are aiding and abetting, felony murder, or both. And it's all a form of imputed liability, right? Like, you don't have to prove the act in some cases or the intent in some cases. And when you combine them, you don't have to prove either. And we looked at it in terms of race, and Black defendants in particular, 25 times more likely to be charged with serious forms of first degree felony murder and the aiding and abetting robbery subtype. And so what, we found is that depending on areas, there's sort of a concentric circle around an offense, and everyone in the vicinity is charged. And again, I'm not trying to impute malintent here on the part of prosecutors, but sometimes the roles themselves are sorted later. right? And so there are people that are bystanders or who are assumed to be part of it because there's a presumed gang affiliation, which I think all of us realize is a pretty loose concept. But once you're charged, and particularly charged with first degree, which is not hard to charge, you are being then advised that you're facing a life sentence. So a lot of people who have no weapons who are there, and it's often, a transaction gone wrong, plead out. And again, like certain counties historically, not as much now, but Hennepin in particular charged. I mean, the racial disparities in Hennepin and those charging decisions are extraordinary.
Especially during that time.
Yes. Yeah. I mean, generations of young Black and brown men. So I think those are just really important, and there's no mechanism to review them in a lot of cases if it's not us. And again, not minimizing the harm to who are disproportionately also Black and brown. I digress.
Yeah, I'll make a note for the public that these kinds of conversations can only happen in open meetings. So we don't always have the opportunity to discuss this and each individual's expertise on different issues. And I appreciate when they come up and we have some time to talk about it. So my question for the commission is, do we want to keep going through additional cases? So far, it seems clear to me that if this discretion is used, it will be used very sparingly, which was something that we considered when creating these. So we can either continue going through cases. So far, there were, I think, only 2 that we considered potentially denying without a hearing, but we haven't made any motions or votes yet. I'll just put that question out there. Or the other thing that's been going through my head is if there are people who may just be deprioritized and stay on the list, we may have to address that through changing our communications and letting them know that you may not get a hearing, which we've talked about doing. So that's another option. So I guess I'm looking for guidance on how we want to use the next 30, 45 minutes.
This is Commissioner Crawford. I want to really thank the screening team for putting this together, and it was just, very helpful to see and have time to really look at all the commutations this time. I think we move forward with the 3. I don't have any others that rise to the level for me. And I appreciate the other commissioners bringing those names forward.
Yeah.
On some, because I had a lot of question marks and when others brought those up. It's good to have that conversation, so I appreciate that.
Yeah. I agree with Commissioner Crawford. This is Commissioner Mesrick. But I do think it's be very helpful to make sure that we are crystal as clear as we can be on communicating with applicants so they understand what's happening.
So do we want to go through any of the cases we haven't discussed?
Commissioner Moriarty, I don't know that we need to myself. I think we've gone through a pretty strong and representative group.
Agreed.
All right, so the 3 names that I haven't, I don't remember where we landed on the last one, but it was Elijah Millsap, Clinton Omoya, and John Martin. And we might have.
Thought we had decided to keep Martin on the list and
Yes.
that the other 2
Right.
we had thought they would be released prior to our hearing them, and that it would provide clarity for them if we were to say, you know, we're denying without a hearing at this point because your release date is, well, we'd have to do it within the statutory criteria, but
Yes.
We can
Yes.
include that as part of,
additional language.
yes, because Elijah Millsap, he has exhaustion of remedies or failing to exhaust remedies because he has a couple of claims related to ineffective assistance of counsel and one other thing that have not been raised. And the commission isn't necessarily in a place to weigh in on those kinds of procedural issues. So we would need a motion. Well, we don't generally do motions when we're talking about grant or deny. But I think in this instance, since it's a new process, a motion to recommend denial without a hearing and a second, and then we'll have to do a roll call vote.
For each case.
Millsap?
Yeah, we're just on Millsap right now.
I'll make the motion. Commissioner Bad Purple.
Second, Commissioner Messrick.
All right, I will call the vote. Commissioner Bad Hartful,
Deny.
Commissioner Burt,
Deny.
Commissioner Crawford,
Deny.
Commissioner Graves is absent, as is Commissioner Harrington and Commissioner Lindstrom. Commissioner Messerick,
Deny.
Commissioner Moriarty,
Deny.
Commissioner Roller.
Deny.
Yes, thank you.
6-0.
Motion passed, 6-0. Elijah Millsap's application will be denied.
The commission recommends
Excuse
denial.
me. Yes, recommends denial.
All right, and for that one, it's based on. And in addition, the sentence will likely expire before we are able to hear it. That was,
Yes.
and what I will also do is add the language, similar to what I said about the commission is not in a position to address procedural issues as those raised. All right, the second one was Clinton Omuya.
And I can make that motion, Commissioner Crawford.
Commissioner Roller seconds.
And that's a motion to deny without a hearing based on the applicant's current challenge of a conviction or sentence through state court proceedings.
Yes.
Right, Commissioner Bad Hartful,
Deny.
Commissioner Burt,
Deny.
Commissioner Crawford,
Deny.
Commissioner Graves, Harrington, and Lindstrom are absent. Commissioner Messerick,
Deny.
Commissioner Moriarty,
Deny.
Commissioner Roller.
Deny.
All right, so motions, got it.
Motion carries on the vote.
Yeah, motion carries under the vote of 6-0 from the Clemency Commission to recommend denying the application.
Yes, and I will add the same
Language.
language. All right, so we have before we move on from this. So what I will do is schedule a meeting with the screening committee. And we'll go through these commutations and others and talk about if we can more clearly define prioritization criteria and if they can help us identify which cases to prioritize. The next thing we have on the agenda is monitoring reports. It was scheduled to start at 1 p.m. We have lunch arriving at 11:45.
I have a quick question. Were we gonna vote on Lupke? Matthew Lupke? Oh, it's not eligible anymore. That's why we don't need to. Okay, thank you for the clarification.
We take a quick bathroom break.
Yeah, that's all.
Yes.
Um,
We're in
So moved.
recess.
Yes,
I will move.
yes, commission will recess for 10 minutes. Return back at 11:40.
Yes.
Go ahead. Kelly?
She's here this summer.
Yeah.
But she's going back. She's one more year.
Awesome.
Okay, welcome back. The Clemency Review Commission we are back live. And we are going to go over governance. Go ahead.
So I was gonna have you lead that. I do have, so the governance report is in your packet. I also included some sample motion language for when we get to that point and a one pager talking about questions to think of as we are reviewing. As the commission knows, we were scheduled to hear the ends policies, which are the overarching goals, as well as 2.1, 2.6, and 2.3. Unfortunately, I was unable to get those other three finished in time. But here, but I will, these report assessment questions are up here. And then as we go through, I have the different policies on the screen, because I think the last time members said that it would be helpful to have the policy on the screen while we discuss the questions. So I will turn it back over to the vice chair to lead the discussion.
Okay, we're going to complete our assessment of doing the budgeting
The ends policy.
of the ends, excuse me, the global ends policies. This is reviewed quarterly. And it covers a day period from September 10th, 2025 to July 1st, 2026. And report was received on July 3rd, 2026. And we will start with 1.1, rigorous investigation assessment of the impact to public safety guide, determinative decisions on granting clemency. And the operational interpretation. Should I read that?
No. So everyone should have reviewed the interpretation and the evidence supporting it. So the questions you would ask, if you pull up the one pager that says report assessment questions, the first one is it a reasonable interpretation? After that, it's does the data in support of the interpretation, is that sufficient to show compliance? And then was the organization in compliance? And if not, why? And is there a report to bring the organization into compliance or a plan? So the first one is the interpretation reasonable?
Yes. Commissioner Crawford.
Are there any questions about the interpretation?
This is on 1.1, right?
Yes.
Okay.
This is Commissioner Byrd. I would say yes. With the published voting records of the CRC and the BOP, that's a demonstrated measurement. And also for our working group, the working summaries definitely meet the operational interpretation, in my opinion. Those are just two large examples of how we are able to do the work and measure kind of the value of all the information that we're getting from staff.
This is Commissioner Roller. Regarding the summaries, I would add, not only are we meeting those expectations, you're exceeding those expectations.
So then the next question is whether the executive director has clearly stated that the organization is in compliance.
Commissioner Crawford, yes.
Commissioner Byrd, I would agree.
Commissioner Messerick, I also agree.
All right, so I think, Glenn,
Yep.
correct me if I'm wrong, we'd go to the next policy and we don't vote until we get to the end of the report.
Okay. Thank you. Now we'll move on to the next, 1.2, board policy, which is there is a clear emphasis placed on rehabilitation, victim services, and restorative practices. This is Commissioner Byrd again. I would say that, yes, the operational interpretation on rehabilitation is definitely identified within the summaries. The emphasis on victim services is highlighted by the acknowledgement and note of Gretchen and her work, which is mentioned to all applicants and families and also bystanders. And that information is also made available, I believe, both on the website and in person. And last, a restorative justice training that was provided to the group. And also the information about trauma-informed hearings, which we both had in person and also we had sent to us digitally. With the emphasis on TBI, or traumatic brain injury, excuse me. And also some of the discussions we have had about understanding or working to better understand how sometimes people show up and, you know, they're reliving a very traumatic, you know, the worst days of their lives. And both victims and applicants, and trying to be understanding in recognizing that as a group, some people are long-winded, some people are short-winded, some people are overwhelmed in the moment and don't know how to communicate, because this is something that is brand new, not just to us sometimes, but to them especially.
This is Commissioner Beth Herpel. I would agree. I also think, you know, when I'm looking at some of the updated applications for a pardon and commission or commutation, and just recognizing that the questions that we ask and how we ask applicants, it's not, you know, just a straight, how are you rehabilitated? Like, it's, what have you been doing to improve yourself? It's language that I think will resonate and get us to the kinds of things that we want to, that we're hoping to see in a accessible, I think, equitable way. So I do appreciate the way those questions are framed in the applications.
Just going to say one thing you could add to the piece on rehabilitation is just that there's emphasis in the summaries on summarizing sort of all of the efforts included in the application for the board's attention. I mean, I think so what you're supposed to do in the interpretation is, am I right, Carly? List what we actually do to comply with, to interpret and then comply effectively.
Yes, so I list my interpretation of anything that is unclear. In this one, the ends report was a little bit different than the ones we've done before, just because it's so broad. And there are some things that systemically we can't necessarily address. So my interpretation was aimed at saying, what can we do and how are we going to do it as an agency? And then talk about, you know, how can we demonstrate that we are actually doing that work?
Yeah, so I think, I mean, everything makes a ton of sense in terms of we're considering the efforts, we're including questions in our applications to elicit the information, and then we're summarizing the information. That makes sense.
This is Commissioner Burt. I also think that part of this interpretation should include some of the positive affirmations that the commission gives to applicants sometimes. Even if there is a denial, there's usually an opportunity to try to highlight the good that's been done. Or if there's someone who's told to come back, maybe withdraw or come back. The idea of trying to give as much guidance as we possibly can in a positive manner, which may inform others who are coming behind them.
We're not voting, we're just.
We're just going through.
Yeah,
So if
great.
we're ready to move on to 1.3 is victims have the resources, support, and access necessary to meaningfully participate in the process that minimizes re-traumatization.
I'll just say this is the hardest one for me to know because I don't know. I mean, just from what I understand, talking to various victim support groups, I mean, there's minimal funding, but there's not necessarily, I mean, again, the most difficult part about this for me is probably beyond our scope, but it's that, there's a sentencing and then no one talks to survivors or victims for that period. They get something from us. I mean, those of you who do this professionally know a lot more than I do, but I don't know that we can do anything about that interim period, but it seems remarkably cruel to me. I mean, it's systemic. It's not, an individual stopping point decision, but to then have people have to come in sort of repeatedly, but having had no support. But yeah, so I do think the training we go through is really important and to articulate and respect it, but just broadly, it's not enough. I mean, I think one thing that, if we're looking for, this is not part of our compliance, but I think all of us are now in a better position to testify in support of mechanisms to generate more funding or different sort of, I think it serves everyone well, both the applicants and the victims and survivors, because it's a lot of times people just want to know what's happening and that, that people are working on themselves on the inside, et cetera. Like, I think it actually serves outcomes all around, but we as a country do it really badly.
Mm-hmm. And this is, sorry, this is Commissioner Burt.
Gretchen too, yeah.
I'm sorry.
Go ahead.
Oh my gosh, I don't know what that's all about. Maybe I'll just speak louder. The one thing I would say that I think as commissioners, you can demonstrate, a lot of victims really don't want to come here at all, but they feel that if they're not sitting in the room with you or with the Board of Pardons, they will be forgotten. And I always want to tell them that they should feel comfortable to stay home. But I don't always know if I can really, if I'm really being honest when I say that. So if you can continue to, I don't know, just be victim-centered, even when there's not victims here, that will show the public, I guess, that victims are considered, even if they, for whatever, lots of different reasons, can't be here.
Mm-hmm.
Commissioner Roller, thank you, Gretchen. And at this time, I want to thank you and for the work that you do. as well. And even when the victims decide not to come, but they write an impact statement, that's very helpful and important as well. I do agree that, you know, we can do a little bit better in this area. And one of those things, as we have new commissioners come in, moving some of their trainings up. I know that we were kind of practicing around what type of trainings we need, but the trainings have really helped kind of center that trauma-informed focus as we move on throughout this process. So if we could just consider moving them up in the orientation process, that would be great.
This is Commissioner Byrd. I would say that yes, there's probably more we could do, but it's also the idea, as Commissioner Moriarty said, it's a systemic issue, and maybe that's where we would have more voice in trying to help the entire system. Because I think about the mother who had to come to a board of pardons meeting. It still bothers me to find out that an apology letter had been written that she didn't know she had access to, which may have helped her just heal, even in a small way, and trying to develop pipelines for that situation to never happen again, to be an advocate for that within the system. But yes, we are limited in what we can offer as a group, but I do think that part of what maybe we can do is to collect those types of stories to inform policymakers, to try to make the system better. Because like I said, that was a moment of horror for me, of recognizing that you know, I thought that those letters got to the families and not knowing that they didn't in that way, or the information was not necessarily shared unless you signed up for this or signed up for that. And how much of that is not being followed up upon from offices like I work in. So I think that is something that I believe we as a group can highlight, simply for the Board of Pardons and others to sort of rethink how the system is organized. And I think we could be a powerful voice for the victim advocate community to help that work, because in the end, we're gonna be re-traumatizing victims, and you know, we may be kind of a bridge between helping people be better. Leave it there.
This is Commissioner Beth Herpel. One thing, and I know that part of this goes to resources, but I'm also thinking about the environment that we're in, and when you know, victims are either waiting to testify or provide testimony, and or after, just what the environment is that they're in. And I know, you know, Gretchen is a huge part of that and has been lovely and does the best that she can. And is there more we can do? I know, and I've shared this before, when I leave a hearing, I smudge in my car, because that's what I'm taught I need to do before I, you know, take this energy back home to my family. Can we provide for some of our families some of these tools that we know could be helpful? Doesn't mean they have to, you know, we're not trying to force them upon people, but I think knowing that they're available, some of these either medicines or even the space that they're waiting in, if there's some different ways that we can make it more comfortable for people, and also help them to process a little bit, whether it's with scent, you know, visuals. Just I think we could be creative about it. The lighting. I mean, this is it's a tough place to be. And especially when you're reliving probably some of the toughest things you've ever gone through in your life. I feel like there could be some somewhat small steps that we could take to make their experience a bit more comfortable and healing.
This is Commissioner Mesrick. I would also advocate for configuring our space so that victims have a separate space where they can watch the hearing, but not have to be involved in a, you know, we're wide open and I liken it to a courtroom. And I'm sure that re-traumatizes people who sat through trials. And I think the other thing is we really need to emphasize that their voices matter and that we want to hear from them. I'm pleased with the number of victims that have actually come to follow through in this process. And I think that's a testament to Gretchen.
I also have a question. I wonder, I know when folks leave here and it's really hard, you don't necessarily want to follow up and bother them. But I do wonder, do we get any feedback or are there ways to get feedback about their experience and how we could make it better without feeling like we're putting too much on folks?
So we've discussed this as staff, and I know that there is a desire to do some kind of survey. Which I'm not opposed to, but I have been thinking about what return we will get from a survey because we know there's not always a lot of participation and whether the benefits of that are worth the resources it will take to get good data. But I talked to a consultant we have about that just on Tuesday. And if there are other ways to collect data as well besides a survey. Because I mean, I've done a lot of large surveys in the past and we get 20, maybe 30% results. And a lot of them are just people who had the worst experience or the best experience. And so I've been thinking about how to get that.
I guess this is the victim advocate, Gretchen again. When I do a certain amount of informal surveying with folks and, you know, toward the end of the process. So we do get some feedback that way in terms of like advice about what they would do differently or what they thought worked well, but that's in no way like quantifiable. But we do take some input that way. The one other thing that we can think about in this category is that oftentimes the applicants are victims too of other things. So like being victim centered doesn't just apply to the victims that come, but also to a lot of the folks that are applying for clemency as well.
This is Commissioner Roller. Thank you, Gretchen. I appreciate those comments because I think that that's something that's hard to balance as well. Yeah.
So this might,
Commissioner-
oh, go ahead,
please.
go ahead. Oh, go.
Oh, I was just gonna simply say, maybe we're looking at an opportunity in the future to have a group that looks at our environment, as well as what does that mean for both victims and advocates. I was at an event and they had ribbons or buttons for people that did not want to be on camera or their pictures taken. And it's a way to tell media, because I've watched the room change when cameras show up. And if there are folks that don't feel comfortable with their picture taken or being on camera, something simple that we could maybe look at that identifies the media that that person does not want to be photographed or on camera. And I'll pause there.
I guess my question is, and this might not be the right time or forum because we're looking at policies, but I think it'd be helpful to hear the feedback that you're getting about our language, about our, you know, just our approach and what we do, what isn't, you know, what does give people confidence that they can stay home, what doesn't. So maybe now is not the time for that, but I think we should find time, substantive time to get that feedback. It'd also be great to hear feedback from applicants about the same issues.
Okay, moving on to Board Policy 1.4. Underrepresented participants in the clemency process have the resources, support, and access necessary to navigate the process successfully.
Can I just make a comment? This one was really hard to write. It was very difficult. So if there are concerns or not concerns, but questions or suggestions for changing the interpretation next time, please let me know.
This is Commissioner Byrd. I would say that as far as starting up, I believe that you have met the standard. I do believe we could try to do more, but that's part of the outreach that you've budgeted for, and you have other organizations doing. And I also think that part of that is also trying to inform as many underrepresented communities that this process exists. And sometimes it has to come through non-traditional means. I know that you've gone to some barbershops and things like that, where, it's word of mouth, and many communities, that's the best way to get information out. But I know that, well, I shouldn't say I know. I feel like we could do more, but I don't want to even posit that I'm an expert on how that looks. But I do know that, in many communities, you almost have to have someone successfully do it and then utilize them to evangelize the message. And I don't know if we're in a position to do that, or even join with someone to try to help get the message out. But I do think that as far as a future goal, that should be something we should be looking for, because I don't know if the numbers balance out based upon what we see as far as, affected applicants versus who we see show up.
Commissioner Roller, Director Starks, is that community engagement is part of the grant application requirement, correct?
Yes, it's outreach and application assistance.
Okay, thank you.
This is Commissioner Crawford. I know this group is new to our state. Are there other opportunities with other states that we can look at some of their best practices as we continue to move forward?
Best practices related to outreach, or
Yes.
I can ask. I've met with and talked to a number of states about their process. We didn't specifically talk about outreach. But that is something that I can do.
If I may, I fell into an opportunity in my community that was doing an expungement clinic, and I tagged along too. And thankfully, with the help staff and others, I was able to get some documents and printed them off, and kind of made like a 3-ring binder I'm more than willing to share, so folks can at least understand some of the things they would need to get in place and how to contact online to do that. And also in doing so, understanding that some of our communities, even till this day, don't have access to technology. So understanding how do you get to your public library? Can you get access to, and if they're working shift work, then where do they go? Because I ran into that. So there's some opportunities, I think, that, and the other thing is people are, how do I put this? They're making the decision for themselves that they're not worthy. And I just encourage them, go for it. You know, fill it out, do the paperwork. Because we've seen it now where it's changed people's lives. And every one of them, most of them have said, I didn't think I was worthy or had a chance to do this.
One thing I'm wondering, I'm thinking about underrepresented and access. How many languages are the applications in?
Currently, they're just in English. However, if someone requests one, I can send it to be translated. We are almost done with a new application form. The old one, the formatting was so bad that when we sent it for translation, we couldn't edit it and it wasn't in a place where people could fill it out. So now we are almost done with an accessible version of that will have in Word and PDF.
Okay.
And the Office of Accessibility is going to help us
Great.
make sure that the PDF is accessible.
Okay.
And then I'll set it to the translation enterprise translation agency or something. We have a free resource to do that.
Okay.
So we have received some communications in other languages that we can get translated, but that is something that
That part of our budget? I mean, it's not there.
it's free to send it to the
Oh,
that
great.
state
Okay.
agency.
Okay, good.
One of the reasons it hasn't been done, and we've been working on it for a while, is and same with the outreach, is just trying to figure out how to prioritize our work between getting applications ready to be heard
Mhm.
and all of the
Yeah.
other things. And it's something that we've been working on as staff, trying to figure out how to get to those other things because it's not really it's an equitable process if
Yeah.
people can't access
No.
the applications. And so we are trying to make some changes. We hired 4 law clerks who are sitting behind me to try and see if we could provide an opportunity for learning about the process and also, have some help with writing the summaries. But I talk about resources not as an excuse, but as a
Yeah,
reality.
no.
I'm starting to learn more about how resources increase or lack of resources increases the inequity in systems. So it's, I don't have an answer yet. I will be doing another legislative ask and I'm going to try and get some stakeholder engagement. And August is when I'm going to really start working on that again.
The other thing just for underrepresented is, and I think we're tracking demographic representation to some extent, but I think particularly in our first year, I think I was struck, as were others, that the demographic representation of applicants did not mirror criminal legal impact. In other words, particularly within pardons in particular in the first year. And I think that's shifting. I'm hearing that people are more well informed and they actually think it's meaningful. They don't think it's going to be just another closed door. But I'm assuming that could be another operational interpretation, that in order to know whether we're giving access to underrepresented participants, we've got to look at our demographics in various ways.
And it does appear to me that the demographic information has expanded as far as I know at one point in the first year, maybe, I don't think American Indian was listed,
Yeah.
and now it is.
Yeah.
So I have seen some improvement in some of those spaces as far as those offerings.
Yep.
Which I appreciate. but I've also noticed, and also just from going out in community and talking to people, a lot of folks in the Native community still do not know about what we're doing. And they're really interested and really excited about it. I also know that, you know, when I've been in spaces where folks have talked about it, they'll refer to one or two people that we've seen who are active in community. You know, and I don't know if those folks, you know, I think sometimes it's hard. Some folks, you know, are ready and willing to help others and want to do that. Other folks are still carrying that shame and don't necessarily want more folks in the community to know kind of what their story is. And so just being, you know, honoring that and being respectful of that, but also, you know, as a commissioner, and I've shared this before, we've talked about it, but I'm more than willing to make some connections. I have strong connections with Native nonprofits across the state that I know would be more than willing to host and support, and I'd be willing to, you know, come and you know, similar, I think, Carl, to what Commissioner Crawford, what you were talking about, and I would love to see that three-wing binder, because I would be more than open to going into the Native community in some various spaces and having conversations with folks. And we've talked in the past about, you know, some of the I guess, what are the parameters of what you can do, especially when you're in community and folks are like, okay, so here's my story. It's nope. I'm telling your story. Let me give you some thoughts on, you know, the process and help guide you and give you some contact information. But I think, yeah, even us having within the commission more conversation on that could be helpful too.
And can I make a note about the demographic data? So currently on the application, there's a fill-in form. So the reason we didn't see anything related to that demographic was because nobody put it on the form. And then this last year, there were a lot more responses. But we realized that the data, because it was such a free form box, the data wasn't as easy to be analyzed. So I'm talking to, there's an office related to data at the Minnesota Management and Budget.
Okay.
To try and see if we can do check boxes or something to make it still have enough options, but also make it so we can clearly see what is being reported. Because yeah, the second year there were just a lot of things that it shows one person in many different
I know I can't speak, this is Commissioner Crawford, I can't speak for my entire community, but understanding there is a level of trust that still needs to be built. Once people get out of the system off paper, the last thing they want to do is expose and come back again. And I think in our state, we're going to have a Herculean effort for the first immigrant population to be willing to come forward and challenge this. So at some point, there'll have to be a bridge-making opportunity to let them know that this process is safe and they're not exposing themselves or other family members to harm.
Another challenge with the recruitment piece, and we've talked about this, is trying to encourage folks to apply and, you know, balance that with and it may take a while, like
yes,
before you're heard. And I know we're working on that. We're trying to work on that. But it's hard.
I do think the expungement clinics are a really good opportunity, because it was always in the court system before all the laws changed, we would deny expungement, so your remedy here is a pardon. And the immediate response would be, well, how do I do that?
yes.
And I don't think many of my colleagues on the bench knew.
And that's my main method of outreach in community is through our expungement clinics with our office. And you know, Carly's giving me all the paperwork too, because I basically just go around to a lot of meetings and just talk about it and try to encourage people to apply with the realism that it's going to take a year.
Yeah.
Just roughly, it's going to take a year, but that's a year for you to gather, for you to understand it, watch it, maybe come see one. And luckily, there's been enough people who have gone through it that I, know of or I run back into in community, who, I think we could find people who would be willing to help others, or at least talk about their experience. To take some of that mystery out of it or fear, to encourage people, because I think that's the big thing. Some of the folks we're seeing are some of the more courageous ones who, have made that decision in their life that they're just going to try it. What else do they have? And they've been encouraged. And so I think that we should try to capitalize on that as much as possible.
So do we need a motion to vote?
We still have.
Oh,
No.
1.5.
Oh, I didn't see 1.5.
Which is kind of the same.
Same,
right?
But different.
A little.
I'll also let you know, our wait list is now 2 to 3 years.
I believe it.
Yeah, I do too.
Mhm.
So moving on, board policy 1.5, interested members of the public have access to information about the clemency process.
I just want to say I put down our website as like proof. I didn't know how to show proof of the fact that like we answer the phones, we respond to emails. I've gotten feedback that our agency, people are surprised how available we are.
Commissioner Byrd, I don't know, have you guys mailed anything to like applications to any of the prisons or anything? Which is another example. I mean, I'm just thinking of what I've heard, and I think that that's even a step that we can show of the work that's being done. And I think part of it is the outreach that we've done, or just talking about it, explaining it to people in community, what the process is and, where to go. So I think it's been demonstrated. It's just, how do you codify that?
Folks comfortable that, are people comfortable that we're in compliance with 1.5?
Yes.
Yeah.
Yes.
The last one is the global policy, which is the part that starts it. It's very broad. The only thing I defined in there was cost efficiency commensurate with the state's investment. Just because that is, again, a reality we face is time in the day and hours we have to do the work while maintaining, a workforce that doesn't get burnt out.
I mean, I think as long as you're operating within budget, I think that, you're absolutely meeting the interpretation. My question is there more that we as a board could do or a commission could do to, advocate for more budget to do more work, if that's what you'd like?
Yes, and I will provide more information as I start working on the next legislative proposal and our budget proposal. Because it's also about getting support from the commission and support from the principals, the Board of Pardons. And if there isn't enough support for increased resources, assessing what the expectation of the agency is. Because we've currently hit at just about our cap, maybe a little bit over of how many hearings we can do, even though we have,
A lot more to do.
yeah, and we haven't given up on efficiency measures, but I just don't know if that's, if we can problem solve our way out of that.
Mhm. And Commissioner Crawford, just continue to show gratitude for your staff and the amazing work that they've done. I think that one report, I want to say a couple months ago, that showed the number of cases we've done versus what has been done in the past speaks volume. And at some point, we may be able to tie that into a budgetary of how much that, you know, folks are not in the situation is changing. And things for our state, because that was the goal, at least when they put this together, that we saw more cases and opportunities and moving forward in an efficient way to streamline the process.
And if anyone else have anything? So then, I guess I could, put forward a motion to accept this report for the global ends policies as a reasonable interpretation of our policy and that the data provided demonstrates compliance. Can, Commissioner Stark, do you want to take roll?
We have a second.
I
Excuse
second.
me, sorry.
Commissioner Roller seconds.
Thank you.
Commissioner Bad Bull,
Is it approved?
I agree.
Yes, approve.
Approved.
Commissioner Burt,
Approve.
Commissioner Crawford,
Approve.
Commissioner Graves, Harrington, and Lindstrom are absent. Commissioner Mesterick,
Approved.
Commissioner Moriarty,
Approve.
Commissioner Roller.
Approve.
At a vote of 6-0, motion is hereby approved. Global ends policies is accepted. Thank you.
So we should probably talk about the 3 other reports that I was unable to complete.
Yes.
I put aside 7 or 8 full days to work on them and unfortunately was called away. In the meantime, we've hired 4 law clerks. We're about to move offices next week. There are a lot of things going on. So I'm not sure what timeline you all would like to see those. They are all partially done. If this is something that you want me to send as they are ready, and then we'll discuss them at our November meeting, or we could discuss it briefly in the morning at another meeting. So
I would say, if you said November, is that 90 days? Or more than 90?
more than 90, but I cannot do that math in my head right
I know,
now.
I know, I'm trying to myself.
Yeah, it's 120.
120, okay, so the next quarter. I'm sorry,
That makes sense.
yeah, I was gonna say,
And if there's anything that, if you send them as they're ready, and if there's anything that comes up that we want to discuss.
It works.
All right, that sounds good to me. I will keep working on them. Thank you for your grace on that. As you can tell, we're doing what we can.
Yes.
we can do.
Yes, we have nothing else on the agenda.
Right, yeah,
Oh, that's great.
so, with that, motion to adjourn,
As the chair, you have that authority without a motion.
oh.
Go for it.
Well, with that, since we've finished up everything, I move that we adjourn. Anyone disagree?
Oh, no.
All right, then thank you.